Assalamualaikum. My group and I will be presenting our assignment title Group Case Review under title Pre-Incorporation Contract. The case that we will be discussing is Dehan Guru Infra Senja Berhad against Baldah Toibah Prasana Kelantan Senja Berhad and another appeal 2022 for MLJ 51. Before we go into the case, just to give a quick idea of what this topic is about, which is a pre-incorporation contract. That refers to a contract that is entered into before a company is officially incorporated. Usually, this kind of contract is made by promoters who are acting on behalf of a company that does not yet legally exist. The main legal issue here is whether the company, once incorporated, can be bound by or enforce the contract, and whether the promoter can be held personally liable. So, this case is particularly important because it shows how the courts deal with pre-incorporation contract in practice, especially when negotiation breaks down and when a newly incorporated company tries to rely on agreement made before it exists. Also, of the case of Dehan Guru Infra Senja Berhad against Baldah Toibah Prasana Kelantan Senja Berhad and another, which was decided by Federal Court on 7 April 2022. So basically, this case actually started in the High Court and later went all the way up to the Federal Court. The plaintiff or the appellant is Dehan Guru Infra Senja Berhad, while the defendants or respondents are Baldah Toibah Prasana Kelantan Senja Berhad, which is the first defendant, and the Perbadanan Menteri Besar Kelantan is the second defendant in this case. In simple terms, this case is about a failed highway construction project in Kelantan, and the main legal issue involved pre-incorporation contract, also about the promoter's liability and the use of Section 35 of Company Act 1965. So the story starts when the Kelantan state government planned to build a highway connecting Kota Baru to Kuala Krai. To manage this project, the government acted through Perbadanan Menteri Besar Kelantan, which then set up a special purpose company called Baldah Toibah Prasana Kelantan Senja Berhad, which is, as I said, this is the first defendant. So then in 2020 plus, a preliminary proposal was issued, and a consortium known as Consortium Dalim JV or CDJV showed interest in the project. CDJV was led by Dalim Industrial Co Limited, which is the Korean company. Then several meetings took place between CDJV and state government officials, including representatives from the first defendant. So during these meetings, the state government showed that it was willing to award the project to CDJV. So at one point, CDJV asked for a letter of intent because they needed to secure financing from Korean bank. So as a result, the first defendant issued a letter of intent dated 8 October 2012, appointing CDJV as the turnkey contractor. However, CDJV accepted this. A letter of acceptance dated 31st October 2012 was issued. So this LOA include important terms like a maximum professional contract price and also a requirement that CDJV had to nominate or incorporate a suitable company to act as the actual turnkey contractor. After that, on the 3rd December 2012, Dehan Guru Infra Senja Berhad, which is the plaintiff, was incorporated. But 2 days later, CDJV informed the first defendant that this newly incorporated company would be the entirely implementing the project. However, even after that, most of the discussions were still mainly between CDJV and the first defendant, but not directly with the plaintiff. So things started to get complicated in January 2013, which is during a meeting on 29 January 2013, the plaintiff circulated a draft agreement that named itself as the contracting party instead of CDJV. Then, in a letter dated 12 February 2013, the plaintiff proposed new financial terms that were quite different from what had already been agreed in the LOI and LOA. Naturally, this raised red flags for the first defendant. So, the first defendant asked CDJV to clarify the relationship between CDJV and the plaintiff, but CDJV didn't really give a clear answer. On top of that, it later came out that Daily Industrial had withdrawn the consortium, and the remaining consortium members hadn't clearly confirmed their support for the plaintiff. Because of all this uncertainty, the first defendant gave the plaintiff an ultimatum, which is basically saying stick strictly to the original LOI and LOA terms, secure the financial by deadline, or deal is off. The plaintiff asked for more time, but the request was rejected. Eventually, on 13 October 2013, the first defendant officially terminated all negotiations and said it was free to negotiate with other parties. After that, the plaintiff sued both defendants for breach of contract. The plaintiff argued that a binding contract already exists between the first defendant and CDJV, and this contract should also bind the plaintiff as a successor company or under the doctrine of Pre-Incorporation Contract. They also tried to make a second defendant liable by asking the court to pierce the corporate veil. At the High Court, the decision was in favor of the plaintiff against the first defendant. However, this decision was later overturned by the Court of Appeal, and finally, the case was brought before the federal court. Alright, so essentially the case boils down to three big questions. The first one is there a valid contractual relationship that actually existed between the plaintiff and the first defendant? And specifically, do the rules on pre-incorporation contract applies to a successor company like the plaintiff? And in this situation, is the plaintiff even a successor? The second one is, was the defendants stopped or legally barred from denying the contract because they had already been dealing with the plaintiff as if they were the contractor? So, is just by them dealing with the plaintiff making them a party to the contract? And the third one, how does Section 35 of the Companies Act 1965 apply here? This section is the heart of pre-incorporation law in Malaysia. Now let's talk about the legal principles and why the successor argument failed. Under Section 35 of the Companies Act 1965, which is now basically Section 65 of the 2016 Act, a company can technically be bound by a contract made before it was even born, basically incorporated. But this isn't automatic. There are two mandatory requirements. One, the contract must have been made specifically on behalf of the company before its formation. Two, the company must ratify or formally confirm that contract after it is incorporated.
Now I will first explain the decision of the Federal Court, which the Federal Court dismissed both appeals with cause and upheld the decision of the Court of Appeal. The Court found that no valid and binding contract that existed between the plaintiff and also the first defendant. This is because the absence of the consensus ad idem, which meaning there was no meeting of minds between the parties. And then, although there were attempts to replace the CDJV with the plaintiff as the contracted party, then the court held that this substitution was never successfully completed and there was no any evidence of novation. And then as such, any legal effect arising from the letters of intent and letters of acceptance, if at all, was limited strictly to only CDJV and did not extend to the plaintiff. The court further ruled that the plaintiff could not be regarded as representing the members of CDJV, as this was contradicted by the response that received by the first defendant. Therefore, even if a binding contract had existed between the first defendant and CDJV, it didn't create any contractual relationship between the first defendant and the plaintiff. With regard to payment for works done, the court referred to the meeting on 29 January 2013 and the letter dated 18 February 2013, which just clearly stated that the first defendant's obligation was limited to payment for preliminary works only. Even if no contract was eventually concluded, this payment was recognized as being on a quantum merit basis under the Section 71 of Contract Act. Accordingly, this arrangement could not give any rise to estoppel, and the doctrine of estoppel was held to be inapplicable. Then the Federal Court also rejected the application of the promoter and successor doctrine because holding that the necessary material facts were neither pleaded nor supported by evidence, which the High Court had therefore erred in applying Section 35 of Companies Act, which both factually and also legally. For now, I will move on to the ratio disagrendi of this case. First ratio is no contract with the plaintiff. Okay, So the first ratio discernment is that no binding contract that existed between the plaintiff and also the first defendant because of the absence of consensus ad idem. Because the court emphasized that a valid contract cannot be formed without a clear meeting of minds, and contractual liability that cannot be imposed merely based on conduct or selective correspondence. And then the court affirmed that even if a binding contract had existed between the first defendant and CDJV, such a contract could not enable binding plaintiff due to the doctrine of privity of contract, and that any extension of contractual obligations to a third party requires a valid novation, which must be supported with a clear and mutual consent, which in this case, no such novation was proven because the letters of intent and also letters of acceptance were issued solely to CDJV, and at the material time, the plaintiff did not even exist as a legal entity yet, and then therefore the plaintiff could not have been a contracting party. So the Federal Court also criticized the High Court because for relying on isolated acts and fragments of correspondence, which the court reiterated that correspondence must be read as a whole and agreement cannot be artificially inferred as established in Deutsche Bank against MBF Holdings case. And then for second ratio is about the estoppel that does not apply, which because of the estoppel could not be invoked against the first defendant because the court held that the estoppel must be founded on properly pleaded material facts, including clear representation, reliance, and also detriment, which the plaintiff failed to plead and also prove these essential elements. Then the court distinguished this case from Teras Kimia against the Kerajaan Malaysia, which here the payment was preliminary, was governed by an express agreement, which clearly contemplated that the possibility that no formal contract would be concluded. Such payment was made on a quantum merit basis, and it's consistent with the Section 71 Contracts Act and with the principle in the case British Steel against Cleveland. And then as a result, payment for preliminary works could not amount to an acknowledgement of a binding contract, nor could it prevent the first defendant from denying the existence of such a contract. So now I will talk about for the third ratio, which is the final ratio concerning that Section 35 of the Companies Act apply. Okay, so the Federal Court held that Section 35 can only apply if two mandatory requirements are satisfied, which the first, contract must be entered into on behalf of a company yet to be incorporated, and secondly, the company must ratify that the contract after incorporation, which in this case, the Daily Consortium enter into the letter of intent and letter of acceptance in its own capacity, not as a promoter for the plaintiff. There was no evidence that the contracts were made on behalf of that future company, nor was there any valid ratification. So accordingly, Section 35 it was wrongly applied by the High Court. Now, for conclusion, for all, then the Federal Court reaffirmed that contractual liability can arise without consensus ad idem, valid novation, or compliance with statutory requirements, which the High Court's failure to apply the settled principle justified the appellate intervention, and the appeals were therefore dismissed.
In this case, the Federal Court was very strict. They clarified that promoter isn't just a label that you can slap on after the fact. You need clear evidence that the party signing the contract, in this case the consortium CDJV, was acting as an agent or promoter for the future company. But they did not see anything as such. And the evidence also showed that CDJV was acting for itself on its own commercial merits. The High Court thought the plaintiff could just automatically take over as a successor once they started doing the work. But the Federal Court rejected this. Without a formal novation or assignment of rights, you can't just slide a new company into an old contract and say, yeah, I'm the new party. So what about the plaintiff's second argument? They said, hey, the defendant let us start preliminary work on the site, so they must have accepted us as the contractor. This is the doctrine of estoppel. However, the court said, nope. The evidence showed the defendant was very careful. They had agreed to pay the plaintiff on a quantum merit basis, which basically means that they would pay for the work actually done. But they explicitly reserved the right to walk away if a formal contract was never finalized. Because they had this express arrangement for preliminary works, the plaintiff couldn't use the same work to claim a long-term multi-million ringgit construction contract existed. Essentially, doing a bit of site clearance doesn't lock in a massive project if the parties have reached a meeting of minds, or basically consensus ad idem on the final term. Basically, the main takeaway that we can take from this case is that if you're acting for a company that hasn't been formed yet, make sure the paperwork exactly say that you are acting as a promoter on its behalf. So basically, if you're a promoter, say that you're a promoter. Secondly, do not rely on conduct to prove a contract exists. Get a formal novation in writing. You cannot just simply, because we had a meeting and we handled that, so basically you agree that we are a party to the contract. No, that is not how the court considers things. The third one is that preliminary work doesn't equal a final contract. If the other side has explicitly said they might still walk away. The strict interpretation of pre-incorporation contract under Section 35 of the Company Act 1965, which is now it is under Section 65 of the Company Act 2016. So in this case, the federal court made it clear that statutory relief is not automatic, which is just because a company is later incorporated does not mean it is automatically bound by earlier agreements. To bind the company, two things must be proven. The first one, the contract must have been entered into by a promoter on behalf of the unincorporated company. And second, the company must ratify the contract after incorporation. Here, the court found that this was not satisfied. CDJV was not acting as a promoter because the LOI and LOA showed CDJV entered the contract in its own name, not on behalf of the plaintiff. There was also no evidence that the plaintiff ratified the contract after it was incorporated. So the federal court also rejected the idea that the plaintiff automatically became a successor to CDJV. Company law does not recognize automatic succession. Without ratification or a proper assignment, contractual rights and obligations cannot simply be transferred. So, the key takeaway is the mere involvement in negotiations after incorporation is not enough to bind a company to a pre-incorporation contract. Lastly, the federal court also criticized the plaintiff for failing to properly plead and prove the facts needed to rely on Section 35 of the Company Act. The court made it clear that legal arguments alone are not enough. There must be clear factual evidence. Even though the statement of claim mentioned both CDJV and the plaintiff, it never specifically pleaded that the CDJV act as a promoter on behalf of the plaintiff, or that the contract was entered into the plaintiff before incorporation. The court said that simply showing the contract was later extended to include the plaintiff was not sufficient. It also rejected the plaintiff's attempt to raise the promoter argument, which is after the evidence had closed, stressing that arguments cannot fix missing facts. Overall, the court emphasizes that pre-incorporation contracts are very fact-sensitive, and without clear pleading, intent, and proof of ratification, Section 35 cannot be relied on.
In conclusion, the federal court's ruling in Dehanguru served as a crucial reality check. It firmly established that Section 335 isn't a loophole. A company can't claim rights under a pre-incorporation contract unless it proves a clear promoter-successor relationship, which the plaintiff failed to do here. Moreover, this case is a stark reminder about the importance of the procedure. The plaintiff's failure to specifically plead the material facts was a fatal error that cost them the entire case. Ultimately, the takeaway is simple. Commercial intent isn't enough. Strict adherence to statutory requirements and proper documentation remains the bedrock of corporate law. Thank you.